Judgment in the appeal, NYK and Cargill International.
Lord Sumption will explain the judgment of the court.
This appeal is about marine charter parties. It raises an issue which is rather technical, but of considerable practical importance to the shipping community. It is common for the use of a ship to be governed by a chain of contracts and subcontracts. In this case, for example, a bulk carrier called the Global Santosh carried a cargo of cement from Sweden to Port Harcourt in Nigeria. The owners of the ship had chartered her to a well-known commodities group, Cargill International, under a time charter. Cargill did not trade her for their own account. Instead, they subchartered her to a company called Sigma for a voyage. Sigma appear to have further subchartered her to Transclear, who employed her to carry to Nigeria the cement that they had sold to a company called IBG Investments. In such cases, the question arises, how are the obligations of the time charter at the top of the chain to be performed? The usual answer is that it will be the companies at the bottom of the chain, in this case Transclear and IBG, who will perform it. But in that case, what if they fail to perform it properly or at all? The question arises in this case because the time charter at the top of the chain had a clause saying that the vessel would be off hire during any period when she was under arrest, unless that was due to the personal act or default of the charterers or their agents. The vessel was arrested and, as a result, seriously delayed while she was in Port Harcourt as a result of a dispute between Transclear and IBG about IBG's failure to pay demurrage under the sale contract between them. The question was whether Transclear and IBG should be treated as the agents of Cargill so that the delay resulting from the arrest could be attributed to Cargill and the vessel put off hire. The arbitrators said no. The dispute between Transclear and IBG was nothing to do with the time charter as Cargill and was not done on their behalf. The judge disagreed. He held that in the relevant respects, Transclear and IBG were acting on behalf of Cargill. The vessel was therefore off hire. The Court of Appeal, albeit for rather different reasons, agreed with him. The Supreme Court, by a majority of 4-1, allows the appeal and restores the decision of the arbitrators for reasons contained in a judgment which I have prepared. When there is a chain of contracts for the employment of a ship, each party in the chain is not, strictly speaking, the agent of the party above him in the chain. But in shipping contracts of this kind, agent has a special and extended meaning. The rights of the time charter at the head of the chain are made available to the parties down the chain, and the obligations of the time charterer are vicariously performed by the parties down the chain. They are referred to as the time charterer's agents for the purpose of performing the contract, and the time charterer may be liable if they fail to do it or do it badly. But it doesn't follow that everything that these so-called agents do is to be attributed to the time charterer. The only functions of the parties down the chain that can be attributed to the time charterer are the functions that serve to discharge the time charterer's obligations under the charter party to which he is party. And that was the problem here. Under the time charter, the charterers had no obligation to discharge the cargo at any particular time, but under the sale contract down the bottom of the chain, the receivers, IBG, were bound to discharge it within a limited time from the vessel being ready at the port of discharge. By doing nothing for several weeks after the ship arrived at Port Harcourt, IBG were not vicariously performing any obligation of the time charterer. Moreover, the arrest of the ship, which is what caused the relevant part of that delay, was nothing to do with any obligation owed by Cargill under the time charter. The only possible basis on which it could be regarded as the act of Cargill's agent is that by subchartering to Sigma, Cargill made possible the chain of contracts which put Transclear and IBG in a position to delay the ship by their own disputes. The Court of Appeal appeared to have been attracted by that argument, but the majority of this court considers that it is far too loose a connection to make Transclear and IBG the agents of the time charter. The appeal will therefore be allowed.